Hey everyone, welcome back to another session. And like I told you, we are all about growing and scaling. But when there's scaling and growing of coaching businesses, a lot of times there's like some things that can be improved with just a little bit of a legal advice. And so we have Alyce Zawacki from a company called Alyce Zawacki Law. And Alyce is going to talk about legal essentials for coaching businesses.
Thank you so much for the introduction, Natalie. As Natalie said, I have my own practice, Alyce Zawacki Law in Austin, Texas, and my focus is really on creatives and creative businesses, including coaching businesses. I've worked with a variety of coaching businesses in spiritual realm, health realm, business coaches, life coaches, and so there's definitely a lot to think about in the legal area. And what I really want to focus on today is kind of just reminding a lot of you about what some of these legal things are. Often with coaching businesses in particular, what I see is that businesses scale very quickly and and growth happens very quickly. And what that means, as Natalie kind of alluded to, is that often the legal things are kind of left behind or haven't been revisited in a long time. So I'm just going to go over kind of those legal essentials and get you all thinking a little bit about the legal side of things with your business. So, the very first thing I want to touch on is trademarks. This is an area that I am seeing a lot of issues happening at the moment. There's been an increase with the USPTO trademark office of about 200% in trademark applications in the past 18 months. It's taking 9 months for them to even look at applications at the moment. And so that just gives you a little bit of insight on how seriously I think people are taking trademark registrations at the moment. And I think a lot more people are just realizing how important it is to protect your branding. So with trademark, I think a lot of people think of the standard trademarks that you may get on your brand name or on your logo. But it's also important to think about trademark from a perspective of your product name. And so even if you have a trademark on your brand name or your logo, you may still want to be thinking, okay, do we have trademarks on our brand name or things like slogans as well? If you don't have any trademarks on your brand name, on your logo, or on any of your products or slogans, then it's very important to start thinking about doing this and go through the trademark process. This is one of the areas you really can't do by yourself. I highly recommend using a intellectual property attorney to help you get your trademark. It's a difficult process. It's a very subjective process. And the requirements that you need in your application are very particular. If you don't do it correctly, they will reject it and then you have to respond and it will probably end up costing you more to get an attorney later on to fix the application than to have started out using one. In terms of what a trademark is, for those of you that don't know, it's different to copyright. With trademark, we're protecting your branding. With copyright, we're protecting your creative materials. A business registration, if you have an LLC, a DBA, a corporation, that registration does not mean that you have a trademark. They don't give you trademark rights. They're not checking to see if there are any conflicts for trademark purposes. And so don't think that just because you have a registered business that you're safe in this regard. In terms of what the consequences are of not conducting a comprehensive search and maybe just kind of flying under the radar and not having a registered mark, is that there may be people who have registered marks that are kind of waiting for your business to boom. That as soon as you do, come after you and send a cease and desist and try and stop you from using those brand names. At best, you'll have to rebrand. At worst, they sue you for trademark infringement and you have to pay damages, which is not great. In terms of what we're looking for from a trademark perspective, we're looking for strong trademarks that are not descriptive of your goods or services. Although descriptive marks are helpful maybe for when people are searching for a particular brand or product, they're not, most of the time, they're not very protectable under trademark law. So we're looking for marks that are kind of creative, right? Arbitrary marks like Apple, for example, before it was connected to computers and software, we just thought of the fruit. And so that is an example of an arbitrary mark where the name doesn't actually give you any indication of what the goods or services are. There are also fanciful marks, which is names that are completely made up, like Kodak, and then suggestive marks that don't tell you what the goods or services are, but kind of allude to them, like Coppertone. There are 42 different classes that you can register in for trademark purposes. These classes are divided into goods and services. And part of the process of trademark is figuring out which classes you should be registering in. With coaching services, we're typically looking at class 41 for educational and coaching services, class 16 for printed goods, and then class 9 for downloadable goods and things like downloadable videos and courses as well. When we're looking for conflicts, what we're really looking for are marks that are similar in sound and appearance that sell the same or similar goods or services. This is called the likelihood of confusion test. It's important to note that just because you spell something different or just because you maybe add a term into your mark or join the words together, that generally is not going to be enough to make your mark distinguishable from a mark that is already registered with the USPTO. Another reason why it's important to do that comprehensive search with an attorney so that they can really tell you what your risks are before you go and register. The other thing with the registration process is it's all public. And so as soon as you register, everybody is able to see that registration. And so sometimes it can be better not to register than to register already. So moving on to business formation, there are definitely entity considerations. I'm sure a lot of you already have a formal business set up, such as an LLC or corporation. But if you don't, you definitely should be looking at setting up that formal business entity because it is going to give you liability protection so that your personal assets are protected from the business assets and vice versa. So in the event that somebody does sue the business, the hope is that your personal assets are protected in that lawsuit. The other thing to think about with LLC and corporation is whether you have the right tax selection. The great thing about the LLC is that it is a very flexible business entity and you can elect S corp tax status. Now, for some of you that may currently not have S corp tax status, but are making, around the 100,000 mark, there definitely could be some tax savings there that you could be taking advantage of because with S corp tax status, you pay less self-employment taxes. So definitely meet with a CPA in order to get some advice on that front. If a business is going well and you originally set up your business with a service such as LegalZoom, I highly recommend that at this time you hire an attorney to go through your formation documents and make sure that everything was set up correctly. While some of these services are very convenient and cheap and can be good to use, but once you're getting to a level where revenue is being generated and growth is happening, you really want to make sure that that business had been formed correctly from the get go. I often see, especially with LegalZoom LLCs or LegalZoom corporations, that unfortunately there has been something that has not been filed right. So go and get those documents reviewed. You also should definitely have insurance. If you do not have insurance, although the LLC and corporation will protect you to some degree, you still want to have that insurance there to protect you in the event of a lawsuit. The other thing with business formation is really the importance of written business agreements. So, regardless of the entity that you choose or the entity that you are operating under, you should have a business agreement. And these have different names like an operating agreement, a company agreement, a partnership agreement if you are not incorporated. And even if you're a single member, say you're a single member LLC, you still want to have a company agreement. The reason being, if something happens to you as the single member owner of that company agreement will set forth a successor plan. And that will say, in the event of death or mental incapacity, there's somebody that can come in and run the day to day operations of the company and do what they need to do. So if you're an individual and you don't have a company agreement, definitely something you want to look into. What's even more important is that if you have multiple owners that own your business, that's even more important to have a written business agreement between all of you. I see a lot of disputes, and it is so difficult when we are going back and there's no company agreement for us to look at because it does mean that the state default rules apply and they aren't that great. For example, here in Texas, if you do not have a written company agreement and for some reason somebody wants to leave the company, they can just sell their interest in the company to whoever they want. They may be forced to dissolve the company if they want to leave. And so it kind of creates all these complications that could have really been avoided by just having a well written business agreement and company agreement between all of the owners. The other thing to keep in mind is that maybe you do have a company agreement or you think that you have a company agreement. Again, it is important to revisit this, to have a look at them and just make sure that everything is, as it should be. Get an attorney to review it. If you used a third party service like LegalZoom and you got a company agreement through them, you definitely want to have a tailored company agreement drafted instead. So moving on to copyright, and this is an area that I help a lot of my coaching businesses out if they have courses, but not only with courses, also with other materials that you may be creating, you can get copyright protection on those works. Copyright is automatic under the law as soon as you fix a creative original work in a tangible form. So, say as soon as you write it on paper or save it to a computer, you automatically get copyright protection. However, here in the US, a few years ago, the courts said, yes, you have copyright protection, but unless you have a registration with the US Copyright Office, you actually can't sue anyone. So at the moment, even though you may have copyright protection, you don't actually have anything that you can do with it. So that's why it's important to go ahead and register with the Copyright Office. The Copyright Office also, if you have a registration and you do it before an infringement occurs, you also get access to statutory damages. And that means that you don't have to prove that damages were done. The courts can just award an amount of damages. It's between about $300 and $150,000, depending on what the infringement was and the facts of the matter. So that's another reason why you should go ahead and get a copyright registration. In terms of what is copyrightable, creative works are copyrightable that are original. There is no protection for copyright purposes in titles, short phrases, facts, useful items, or ideas. And ideas is a big one because I often have clients come to me who say, I have this awesome idea, or I want to protect the mythology of my course or the model of my course. Unfortunately, we can't protect the idea itself, but we can protect the materials that express those ideas. So if you have lesson plans or if you have the processes written down in a document, we can go ahead and copyright those types of things. Videos that you may have created, we can copyright. In terms of the Copyright Office process, it's relatively easy, unlike trademark. Trademark's a lot more complicated, but it certainly has its quirks. And there are different applications that you can use depending on whether the work is published or unpublished and how you may be able to group those works together. For coaching businesses, you may want to copyright things like lesson plans, videos, courseworks, worksheets, or if you've released a book, you should get a copyright on that book as well. It's taking about 1 to 10 months to process with the Copyright Office. At the moment, it's actually pretty quick. I got one back last month in about 4 weeks, so pretty quick. And you do upload copies of the work to the Copyright Office as well. So, taking a look at copywriting specifically for courses, because I'm sure a lot of you have courses, if the course is not delivered in one continuous presentation, you're probably going to need to submit separate applications for the course. With courses, I do recommend working with an attorney because it can get kind of complicated and you want somebody to assess which is going to be the best application to save you the most money. For example, a group of unpublished works is $85 and you can register up to 10, whereas a single work is $65 if it's published. So it's going to be better if you can to copyright your course before you launch because you likely will need to separate out the literary work. So separate out the lesson plans, the worksheets, copyright them in one group application, and then separate out the videos and copyright all of the videos in one separate application as well. So it takes a little bit of maths to kind of see which applications are going to be the best, depending on the format and your distribution model for your course. I'm very hopeful that the Copyright Office will eventually create a separate application for courses in particular. At the moment, it's just a little bit more complicated than what I think it should be, but we will see if that happens. Looking at service agreements, probably one of the most important things that you should be thinking about. A formal agreement is always best. And your coaching service agreement can be used for one on one coaching, group coaching, and mastermind services. I do see some clients who have these kind of separated out into service agreements. But if you work with an attorney, typically they can create a template service agreement that you can then customize for one on one, group, or mastermind so that you don't have to have three different contracts that you're thinking about. Which one do I use for this situation? Contracts don't need to be full of legalese, but they do need to sufficiently cover your business, especially from a liability perspective. And these are living, breathing documents. These have to be amended as your business changes. If you have not reviewed your service agreement in a little while, I highly recommend working with an attorney to get a review done. Laws change. If you worked with an attorney, I'm sure they developed maybe new practices that they're now implementing. And so I do recommend reviewing service agreements at least every 2 years. Looking at what should be included in your service agreement, you want to be very specific about the services that you're providing. Scope creep is not good, especially if you're doing flat fees. It's very easy for clients to think that you're providing one thing and then keep on asking. And if you don't have a clear scope of services, that can really cause issues in terms of determining when you charge them an extra fee or not. You want to have some language about changes to services, stating that they can't decrease the services. Fees, are you charging hourly rate, flat fee? Are there auto renewals? Do you get upfront payments? Is it like a monthly subscription? All of those things need to be dealt with in the service agreement. There's also confidentiality, privacy, and access to data concerns, especially if you are a business coach or a health coach, and maybe you're getting access to health information or private business information. Those really need to be addressed clearly. You also should have disclaimers if you're not a licensed professional in the area, and make it clear that what you're recommending as part of your coaching services are recommendations only. Client commitment is also very important. Most coaching services are dependent on your client committing to the program, putting in the work, doing their homework, and listening to feedback. If they're not doing that, you want to have some language that deals with maybe termination and non refundable fees if you're kind of getting a client that's just not doing the work. Liability and indemnification need to be addressed, ownership of your content, publicity permission if you do want to maybe record parts of your services and use them for publicity purposes. And then, of course, kill fee. If a client does want to terminate, how much do you charge for the kill fee? Do you refund anything? That needs to be addressed very clearly. I'm going to touch briefly on contractors and employees. I'm sure a lot of you are kind of getting to that stage or are already at that stage where you are thinking or have contractors or employees. In terms of the difference between a contractor and an employee, it's very important to know and classify your workers correctly. It does depend on the relationship of the parties. The IRS typically will focus on the control of the process. If you're controlling the process, you're more likely to be an employee versus just giving someone the work and they control the method and the process. Other things like exclusivity, determination of work hours, whether it's a specific task versus a long commitment, how that person is invoiced and taxed, benefits that are offered to them, whether equipment and materials and uniforms are provided as well. If you're misclassifying people, there is the potential for you to get fined, for you to be sued, and for you to back pay. So you definitely want to work with an attorney in your state to make sure you're classifying your workers correctly. Every state is different. For example, California is very strict on this and has new laws in place. So you want to make sure that whatever state you're working with, you're clear on the laws for your particular state. Things to think about in contractor and employee agreements: compensation, delivery of the work, whether they need to have any qualifications or licenses to do the work, what their hours are, whether there's any benefits such as vacation, sick pay, and healthcare, ownership of the work product that they're creating. You definitely want to make sure anything that they're doing is owned by you. Non disclosure agreement, non solicitation and non compete. Non solicitation would stop an employee or contractor from taking your clients or taking your other employees or contractors and working with them behind your back. A non compete can potentially stop them from operating a similar business in a similar area. These have to be very specifically tailored, and non competes in a lot of states, such as Texas, are pretty hard to enforce. Use of the employees or contractors' name, image, and likeness if you're showing them, putting them on your website, use of social media, and then, of course, termination, how that person can be terminated from your business. Some other considerations: employment issues, immigration issues, the Equal Opportunity Act, Equal Pay Act, Affordable Care Act all come into play here as well. And then, of course, employee compliance training, especially in the areas of privacy. If you're dealing with any client data, you want to make sure that you have a very clear privacy policy in place with your employees so that they know what they're doing. Online security, ADA, harassment, and then other technical training that you may need to do as well. In addition to having a contractor agreement and an employee agreement, I also highly recommend having an employee handbook that cover more of your general policies and those that can be changed at any time as you choose. Also, make sure to think about state specific wage, healthcare, overtime, and sick pay requirements. These vary from state to state. And then, of course, tax implications as well. Privacy policies. So I'm sure a lot of you are online businesses. It is mandatory to have a privacy policy on your website if you are collecting personal information. And even if you don't think that you're collecting personal information on your website, I can almost guarantee that you are. If you have any sort of newsletter sign up, a contact form on your website, if you accept credit cards or you have a blog that people can leave comments on, if you are using cookies or you use Google Analytics, all of these are going to implicate you in collecting potentially personal information from your users on your website. Other considerations with privacy are HIPAA and COPA. COPA deals with children accessing, if you have any sort of business that's aimed at children. The California Privacy Act, the GDPR, which is the European Privacy Act, credit card processing. If you have targeted advertising, there's a whole body of laws that surround targeted advertising as well. With privacy policies, it's my opinion that these really need to be specifically tailored for your website. So, again, if you have purchased maybe a privacy policy template, it's best to have that reviewed by an attorney. As you grow, risk becomes larger for these issues to come up. And so, having that reviewed and tailored is very important. Also, looking at terms of use for your website. So these normally go hand in hand, right? You'll normally have a privacy policy and then a terms of use on your website as well. The terms of use isn't technically mandatory like the privacy policy is, but it's highly recommended. This is going to set forth your terms for using the online website or your online services. Highly recommended for any business that has any sort of e-commerce element, social engagement element, like a blog or a Facebook community, or if there's the ability for users to make public posts on the website, or any website that requires a user to make an account as well. You're going to want to have this terms of use policy. Again, should be specifically tailored for your website. If you're working off a template that you maybe purchased, time to get that looked at, time to get it reviewed and make sure that it is specific for how your business and how your online services are actually operating. In terms of what these address, we're looking at how the services are used, how access is granted to users, your refund, exchange, and shipping policies if you have physical products, IP ownership, social engagement rules, the ability to remove and delete accounts if you no longer want somebody using your services. You want a technology error liability disclaimer that deals with things like maybe if your product isn't correctly described on the website, or if you have downtime on your website, or there's some sort of payment processing error that happens. User content disclaimer if you have people who are able to leave comments on your website or your online services. You want to make sure that there's some rules around that, right? In terms of what they can and can't post, warranties, and then, of course, affiliate link disclaimer. This is a big one I see with a lot of my coaching clients where they have links to products or services and they're getting a commission or a benefit from that link whenever someone clicks on it. there's very specific affiliate link disclaimer language that needs to be displayed on your website and displayed in your terms of use if using affiliate links. All right. This is a coaching business legal checklist of just everything that I've given you an overview about. So we have trademark, business creation, taxes, copyright, service agreements, privacy policy, terms of use, insurance, contractor employee agreements, and of course, non disclosure agreements, which I didn't touch on too much. But if you are sharing any business information with anyone, whether they're an employee, a contractor, or a vendor, you're going to want to make sure you have an NDA with people as well. Wouldn't be a legal presentation without a disclaimer. So this is just for educational purposes. And this doesn't create any kind of client attorney relationship. And these are my details. I've tried to be on time and it looks like I've got 1 minute, but maybe if anybody had any questions, I'm open to taking them.
That was a very packed session. There's so many things. I am going to ask for you to share a link to your presentation if that's okay. I'm sure people were trying to take some screenshots. And so I will share it with everyone who asked me. There's a lot of checklists and a lot of things that need to be taken care of. And it looks like too many things to do within the time frame that everyone has, right? So like, I'm really curious to hear how all of that is possible. Generally speaking, I would love for you to come back doing another episode like this. We can do a podcast episode where I would just ask all of those questions. And I have so many more legal questions that I know people that work with us also have. So if it's okay with you, let's do a session and it can be a podcast episode. And I would love to ask all of those questions, but we are right at our time right now. So I thank you so much, Alyce, for joining us today.
That's a great, and I'm happy to meet with you. And if anybody has specific questions, please feel free to email me. I'm happy to answer, and I'll of course provide these slides for all of you.
Awesome. Thank you so much.
Thank you.
Everyone, I'll see you in the next session.